Court. Welcome, everybody. We got our friend, UK patent attorney David Pearce back on with us here today. This is Gavin Mehl, and we're going to be talking everything about what he's been up to and the court trial and Copa v. Wright and his perspective and just shining light on this whole situation from his perspective. So, David, good to see you again. How you doing?
I'm doing great. Good to see you too, Gavin.
So I hear you've been on some Twitter Spaces lately. What have you been up to?
Yeah, there were a couple. I met a nice guy, Aaron van Verden, Dutch guy who wrote the Genesis book, which I've just started reading about the history leading up to Bitcoin. Met him at the court on the first day. He invited me onto Twitter Spaces. I did that a couple of times during the trial. That was interesting. And then we had another one last weekend where we talked about the aftermath of what happened last week. And I had a few thoughts. But yeah, where do you want to start? How do you want to start this? Should we start with what happened at the end of the trial? Because
I would love to get your perspective on what happened at the trial. And I've got I've got a bunch of questions. I'm going to try to narrow in on the best questions I got here from Twitter that are relevant. And I'm going to go to those, but why don't we just kind of
sure,
go onto your perspective, and again, I'm not here to lead you and say, oh, this happened, that happened. I want your perspective on what you saw and what you believe is going on in the court. So I would really value and appreciate that.
Yeah, well, I mean, if we start with what happened in the last couple of days, so the closing submissions, a lot of it was just going over what we'd already heard throughout the previous few weeks, and it was a summing up. So Copa did the bulk of that summing up. Unfortunately, I've been doing lots of work, lots of patent drafting, so I wasn't able to watch all of it. But I did catch some of Jonathan Hoff, and certainly I got all of the last morning's closing from forgotten now, Lord Grabiner, KC, and then obviously the final bit from Sir James Miller. And just because there's been a little bit of, I wouldn't have expected this, but there seems to be a bit of controversy about what was actually happening at the end, what James Miller actually said and what it meant. So I think it's maybe useful just to read out from the transcript which I've got in front of me what he actually said.
Please do.
Which is, it's only a few, it's not long. So he said at the end when everyone had done their closings, said thank you to everybody, and the judgment he's going to have to prepare will be a long one. So who knows how long that's going to be, but it's going to take him quite a while to do. So and he also said that his clerk had been hassled by well, his clerk has had a hell of a job in the last few months responding to, I think it was getting on for about 1,000 people who are watching this online. So
yeah, I heard at least 1,000.
Yeah, the number of emails that she's had to deal with is just, yeah, a lot. So
it's probably similar to the Twitter comments that we get, I'm sure. So it's a lot of
yeah. So I think partly because of that, that what should we call him, Mr. Justice Miller, should we call him really? He obviously decided that he had to say something at the end of this trial, just to kind of calm down the inquiries that he'd been getting and to stop people pestering him. He didn't want to be pestered for the next God knows how many weeks or months that he's going to take to write this. So it's partly because of that, but also let me just go into what he actually said. He said, having considered all the evidence and submissions presented to me in this trial, I've reached the conclusion that the evidence is overwhelming. Now that I was watching it to that point and I thought, oh, hang on, what's going on here? So I was as puzzled by everyone. I wasn't expecting any sort of decision, declaration, judgment, however you want to put it. But then he said, therefore, for the reasons which will be explained in that written judgment in due course, I will make certain declarations which I'm satisfied are useful and are necessary to do justice between the parties. And then he does these 4 declarations. First, Dr. Wright is not the author of the Bitcoin white paper. Second, Dr. Wright is not Satoshi Nakamoto. Third, Dr. Wright is not the person who created the Bitcoin system. And fourth, he's not the author of the Bitcoin software. So it seems like they could all be covered by one statement. He's not Satoshi Nakamoto. He's a very naughty boy, to paraphrase Life of Brian. But there seemed to be some confusion among certainly BSV supporters as to what all this meant. Was he just enumerating things that Copa were asking for, or was he actually making a judgment or a verdict or something? But I think it's pretty clear from what he said, these were declarations because the evidence was overwhelming. So there was no way he was going to come to any different judgment in the end. The only question was how he's going to reason this out to get to that point and detail all the, because there's a lot of documents and witness testimony and allegations. He didn't get one point to note, or there's a few points to note, is that he didn't mention anything to do with forgeries. So he's not making any declaration to do with forgeries, and that was a big part of the case. He's not making any declarations as to do with fraud, because there was an accusation of fraud on the court. He's only making clear statements that to answer the key question that Copa wanted answering. Did he write the Bitcoin white paper? Did he write the Bitcoin software? No. So we can draw a line under that, and everything else is kind of, well, it's secondary. Okay, they're very important, but they're secondary, and everyone wants to know the fundamental answer, which is he's not Satoshi Nakamoto. And this surprised everyone because it's very unusual, certainly in the High Court, to get this declaration at the end of a trial before the judgment. And I think really that the reason for that is because court cases in the UK and elsewhere, things don't go to court usually unless there's an arguable case on both sides. So it's often quite finely balanced. And things like, I mean, the judgments that I read most are patent judgments. So someone goes to court and someone sues someone for infringing a patent, and the other side say, no, we don't infringe, and by the way, your patent's invalid. So there's a fight from both sides, and they have a hearing, and it goes to trial and all that, lots of evidence submitted. And at the end of the trial, there's no way that the judge is going to say the patent's valid or the patent's invalid, and I'll give my judgment later, because there's so much for the judge to take in, and it's usually too finely balanced, so that the judge runs the risk of declaring something that he might change his mind on when he actually goes away and reviews all the evidence. So I think that's the reason we don't see this very much, because court cases are often, there might be, in the trial, there might be 50-50, it might be swinging one way or another, but you're not going to expect a judge to decide at the end of a trial. But from my perspective, I do not before the courts, but most of my experience that's similar to this is before the European Patent Office. So I go before tribunals. There's always 3 people on the other side, before examiners. So you get an examining division with 3 examiners, and you have to argue your case as to why your patent should be granted. Or there's the opposition case where someone else is opposing your patent or you're opposing their patent. And then you come to an oral hearing at the end of the written procedure, and you argue the case either way. And then at the end, in both cases, almost always, the examining division or the opposition division decide. So they issue a decision at the end of the hearing. They say which way it's gone. Usually you can tell by the way that the hearing is going, but they will tell you at the end of the hearing which way they decided. And then you get the written decision that comes maybe 2 or 3 months later. And also in if it goes higher up to an appeal hearing, it's fairly normal for an appeal hearing after written procedure to result in a decision being made by the appeal board. And these are similar, more similar to judges. So this is sort of almost a lower level court judge at the appeal board at the European Patent Office. Similar experience people, and they're deciding on legal issues. So if you're arguing a case before them, they will often, although not always, issue their decision at the end of the hearing, and they'll tell you whether you've won or lost, or which side has won or lost, and then you get a written judgment 2 or 3 months later. So from my perspective, this is normal, but that's probably because the issues that I deal with are much more focused. It's only whether this particular patent is valid or invalid, and there's not lots of other issues to be resolved. It's just that one thing, and all you need to know is whether it is or isn't, and then you can go away and commiserate or celebrate, and then you get the decision later, the written decision later, and if it hasn't gone to appeal, you can then decide whether you're going to appeal it up to a higher level. So this to me looks like a sensible thing to do from the judge, because he clearly thinks he's had enough evidence presented to him, and he can reach at least these decisions. They're not all the decisions that he needs to make, but he can at least reach the basic decisions that will inform the parties. So to use his words, which he's satisfied are useful and necessary to do justice between the parties. So he must mean, I don't want to leave you guys hanging for 3 months or however long it's going to take for me to write this decision. I want to tell you now because I've already decided. I don't want to keep it secret. My decision is not going to change because I've already seen all these. He's read thousands of pages of documents, even before the trial started. And during the trial, he's just been sat there and listening to everyone talk, taking it in, and you've probably seen asking questions at certain points and making very pointed observations, very clever observations in some cases. So he's definitely been paying close attention, and clearly sees at the end, there's only one way this is going to go. So I was watching your, it was a brief chat you had with Jack Pitts.
Yeah, yeah.
And he was saying something very different, which was, Mr. Justice Mellor is going to go away and do some research, and then when he does the research, he's going to find that Craig Wright is Satoshi Nakamoto, and that's just not how it works. If you go back, were you watching on the first day of the trial?
Absolutely. Yeah.
So almost the very first thing that Mr. Justice Mellor said was, he's received lots of books. He's been sent lots of books over the past year or so, and he's not read any of them. So he's probably been sent the Bitcoin Standard and Andreas Antonopoulos' books or whatever else. There are lots of Bitcoin books from well-meaning people trying to educate him on Bitcoin. It's probably been sent books on BSV as well. So he might have been sent all sorts of things. People are trying to persuade him to understand, or not persuade him, trying to make him understand what's going on here. But he made an interesting point of, well, I'm not going to pay attention to these. All he's there to do is all he's going to pay attention to, all he's allowed to pay attention to really, is what the parties have submitted to him. So nothing else. So those are the only things that he's going to make a judgment on, which is all the thousands of pages of documents that Craig Wright's side has submitted, and the thousands of pages of documents that Copa and the Bitcoin developers side have submitted. And that is now fixed. So that's in. Everything is in, and the transcript, of course. So he's got the transcript to go on, which is however many hundreds of pages it will be for the weeks of the trial. So he's got all these to refer to and try and distill into some sort of judgment. He is not going to do any other research. He's not going to start Googling anything. So he's not going to be watching this video.
He's not going to be, yeah, he's not going to be watching my YouTube channel then. Oh, no.
No, absolutely not. Unfortunately.
Darn it. I thought there was a chance. Okay. Yeah.
Yeah, I mean, you could do with some more views, but yeah, you're not going to get one from the High Court.
So let me ask you, thank you for that. That's really helpful. And I wanted before I go to some of the questions from the people online, that was, I want you to explain it was either a motion to dismiss or a procedural, motion that was filed. I think it was on the database rights case, which is not this one, but the one after it. And it was dismissed and then appealed. Can you explain what happened with that and what it was about?
Yes, I can. In fact, I wrote a blog about it. And I've got it up here. Yeah. So that was what's called the Bitcoin file format. No, sorry, that's a different one.
And I would like that blog, and I'll put it in the video description if you tell me how to find it, or you link it to me on Twitter later.
Hang on, no, the one that was appealed and went back to him was the Bitcoin file format. The database rights is different.
Okay, the file format. Okay, please explain from your.
The Bitcoin file format is this idea that hasn't been raised before, and I kind of think I know why, which was there is copyright we call subsist, but copyright is an IP right that attaches to something, some creation. So you write let's say a blog article, then if that's your original work, if you wrote it, then it's your copyright. And the act of writing it creates that copyright. You write a book, and then the first owner of the copyright is you as the author. And the same works, and this is regardless of whether it's US, UK, most countries in the world are the same on this. The US is only slightly different because you have to register it to enforce copyright, but that doesn't matter. That doesn't stop it from existing. So copyright subsists when you create a work. And that also works with software. So you write a piece of software, and it's a long-standing principle that's dealt with in the same way as writing anything else. So writing a piece of music, recording a film, writing a book, creating a sculpture, they're all works on which copyright can attach. And the question in the Bitcoin file format was, the Bitcoin is created in whichever flavor of Bitcoin you want to look at, it's created in blocks. So every 10 minutes, you have a block that's created, and that block has all transactions in it, and it has a particular format to it. So there's a structure to it that allows a computer to read it. So the Bitcoin software has to know how a block is formatted to be able to read it. So you can extract the transactions and all the data and determine which block goes where and what the order is and all the rest of it. And the question there was whether there was copyright in that format. So not the data itself, because the data is different every time. So there are, 835,000, I've probably got there. No, it's not up yet. 835,000 blocks. Each one of them is different, but they all have the same structure, more or less, or they all have a basic structure that's defined in the original Bitcoin software. But you can't tell what that structure is from the block itself. So the argument in the Bitcoin file format case, which was when it first went before Mr. Justice Mellor, it was he was struggling to see where the format was, or where it was, what's the word, where it was recorded. There's a word for it, fixed. Yeah, that the idea is that copyright has to be fixed to something. So there has to be something that tells where is it recorded that this format is a particular form. And he, in the first instance, he compared it to a previous case which was involved. Do you know XML? So XML is a type of storing of data.
XML, yes, yes. That's a
So you
yeah.
get things. So XML is a way of it's like creating a web page where everything has a particular place,
It's a file format.
a file format. So an inside an XML file, there are things in triangular brackets which tell you what comes after, what that means. So if you have an XML file of personal data, so you'd have a name category, you'd have address category, you'd have date of birth category, etc. And so then you can imagine that there'll be a template. So a blank template would have all those categories, but no content. And that XML template was written by a person and structured in a particular way. And there was a previous case that decided that there is copyright in that format. Okay, so you're with me so far. So there.
So far I am, yeah. So then as far as I know, he dismissed the claim.
Yes, but that was because he couldn't see that there was anything in a Bitcoin block that told you what the bits were. Okay, unlike an XML format file where you can see, if you open it up in a text editor, you can see the things in the triangular brackets that tell you what the content is. That's going to be the same every time. If you open up a Bitcoin block and just look at the text or in hex editor, you won't see anything because it'll be different every time. You won't see anything that tells you what the format is. So Mr. Justice Miller on first instance was saying, and he kept asking the Craig Wright's side, where is this fixed? To give me some evidence, show me where it's fixed. And they couldn't come up with anything. They just kept referring to post-dated documents that said, well, this explains what it was. And that wasn't good enough to Justice Miller. So he decided in the end that it wasn't, they hadn't established that there was any copyright that was fixed. So he threw it out. And that was, there's a particular point of law on why he threw it out, but I don't need to go into that. And then that was appealed up to the Court of Appeal. And the Court of Appeal, which was Lord Justice Arnold, who's a slightly more experienced judge, who's gone up one level, he disagreed with that finding because he said, well, the fixation bit doesn't need to be in the content itself. The fixation could be elsewhere. And that's all the point was. And he then said, well, you don't need to establish, all that needed to be established was that there was a serious question to be tried. There was an issue here. It wasn't whether there was copyright, anyone who owned copyright, anything like that. It was just, could there be argued to be copyright in that format? And Lord Justice Arnold said, yes, there could be, but the fixation doesn't have to be in the same place. And then, so then that got sent back to Justice Miller, and the case then proceeded. Or actually, I mean, it ended up being halted because of the Copa case. But that part of the Bitcoin file format case could then be included in that, whichever one that was before the developers, I think. So it ended up, not the part that got rolled into the Copa case, but another part of the Bitcoin developers case.
Okay, that's great. Yeah, thank you, David, for clarifying that on the appeal.
Is that clear enough? Because it's quite a quite obscure point of law, really.
It seems like it is. I mean, basically, it is the obscure point of law is definitely complicated, but it sounds like just overall there was a claim that the Justice Miller, he believed they didn't state a claim, and then they appealed it, and then the higher court said they did state a claim, but either way, it's a moot point right now because it stopped with the Copa case.
Yeah,
because of that.
exactly.
So
close enough. Yeah.
Okay, so let me ask you, there was some communications. Now, this is from Truth Machine, follower of Jesus, Crypto Rebel. He says that
Right.
he wants to know, about some ex-party communication with the court, with somebody on the outside and the clerk. And there may these, whether or not I asked the court actually to clarify if this was genuine, and they never responded. So there was some communication that apparently somebody had contacted the court, and the clerk responded for the judge. And he's saying, can ex parte communication happen between the clerk and the public clarifying the judge's ruling? Is that allowed? I mean, so apparently somebody had wrote up a document saying that here, this is from the clerk and this is what she said. She went and talked to the judge, and so is that even allowed?
I did see that. No, the clerk was just clarifying which is why I quoted the transcript earlier, because the clerk was just clarifying what Mr. Justice Miller had said. Now, it wasn't, I think what she said was it wasn't a verdict because it's not a criminal trial. It was just declarations that foreshadow what the judgment is going to find, but you'll just have to wait and see. So it's not saying anything new. It's just
not ex parte. Yeah, it's not ex parte communication, basically.
I don't really know what that means, whether it's significant at all.
No, I would say, well, he was believing that it was ex parte communication and asking if it was ex parte, if it was allowed or not. So apparently you say that if it is true, it is allowed. What's the
Yeah, I didn't. I saw that it was just a short email, just clarifying what had been said.
Yeah,
that it was.
I saw that too. Okay, this may be a. Well, let me go. Are you Craig? Let's see. Tracking the edge. Ask him if he's a BTC maxi.
How do you define a BTC maxi? Do you mean a Bitcoin maxi? I mean, I know I kind of know what.
I don't know.
That.
He didn't say. I said, ask him if he's a BTC maxi. I'm not sure if you want to. How do you want to answer that? So that's all I got.
Well, I don't have anything other than Bitcoin or BTC, if you want to call it that. And in my view, that's really the only one that matters. So I suppose that answers the question. I suppose the answer is yes.
Okay, fair enough. Yes. So let's see. We got oh boy. Okay, some confusing ones here. Let me actually share my screen, okay? And maybe we can kind of walk through these together and we can pick and choose. So this is there's some confusing questions. Okay, share my screen. Hopefully this is going to come through. All right. Does this come through on the screen now?
Oh, yes.
Okay. I can't really see, this isn't really a question. Why, when he said he's biased, I don't know if that's directed at me or you. I said I'm confused about the question.
I think that's directed at me. I think I did say last time we talked that I was biased. So I'd already decided that Craig wasn't Satoshi.
Okay.
So I don't see that really being a question. So
yeah, and this one I'm confused by. So
I saw that. I think that's someone who's gone off the rails a little bit there.
Okay. Yeah. Birth certificate, maybe like the birth certificate. Yeah, I don't get it. I'm not sure what that.
No idea. No idea.
Okay. This is about me saying that ask me why I'm doing such a bottle job media. I don't know why,
what does that even mean?
I was confused by this one, but I asked him, I said, he says, ask him this. I think it's directed towards me. If I'm more after 1,000 views to impress Craig or 1,000,000 views by providing engaging media, I think he's doing a first silly sausage. I said, how do you suggest I do better at engaging the media? So I don't know. And then someone says, these are just comments. Is there a question? Name calling. I don't know. I don't get it. How likely is it that Craig gets prosecuted? This could be a question. How likely is it that Craig gets prosecuted and convicted for perjury and perverting the court of justice?
Well, that's something that's in the. Let me go to. Hang on, I've got some files open here somewhere.
Want to share your screen on something?
Bear with me a second. No, I was just going through the closing submissions. So yeah, that's I think that's a reference to Copa's closing submissions where they said, and I quote them here, to give fair warning, Copa will ask after judgment that the papers be referred to the Director of Public Prosecutions for consideration of prosecution for the offences of perjury and perverting the course of justice. So exactly what you guys said there.
Hmm.
Um, so what they're referring to is, well, you know what perjury is lying under oath, and perverting the course of justice, closely linked to that. If you're submitting documents, especially during a trial, that are forged, it's again a criminal offence. So normally perjury doesn't get followed through. If you lie under oath, then your penalty is you generally lose the case if the judge spots it. So in a criminal trial, if you plead not guilty, but then you're found guilty, you've by definition committed perjury, but you're not usually prosecuted for perjury. You're just convicted of that particular offence that you pled not guilty to. That's just a standard way things are done, as far as I can see. In civil trials, it's even less common, although it does happen. This is something we were discussing at the Twitter space at the weekend. Mark Hunter had looked up a few past cases, and I'd remembered a few from a while ago. There were three cases that I remember from in the UK that all involved MPs, so members of Parliament, and they were Jonathan Aitken, Jeffrey Archer, and Chris Huhne, and this dates back well, over 20 years for the first two. And Jonathan Aitken and Jeffrey Archer were both involved in libel trials. So they were defending their reputation on whatever it was. I can't even remember for Jonathan Aitken's case, but they both were found to have lied under oath to support their case. And I think they both initially won their libel trial, partly because of what they said on the stand. And I think in both cases it was just one lie. So they just said something untrue under oath, and they both went to jail.
Hmm.
And Chris Huhne was more recent. I mean, it depends how you look at it, but that was even less egregious or serious. What he did was he got his wife to take a speeding ticket for him because he was close to I don't know if you rack up a certain number of points if you got caught for speeding, and once you get to 12 points in the UK, you get a driving license ban for 12 months, whatever it was. So he was close to his limit. And if he'd taken that speeding ticket, he would have been banned from driving. So he was found to have lied by saying that his wife, no, it wasn't me driving, it was my wife. So he got his wife to take those 3 points so that he didn't get a driving ban. And he got into trouble for that. And he was convicted. I don't know if he went to jail, but he was convicted of that. And I think the reason they were all convicted was because they were made an example of. So public figures, they were all MPs. And I think that matters more. If you're just a normal guy and you lie on the stand, maybe you get into trouble, but you don't get done for perjury and sent to jail as an example to others. If
Hmm.
you're a high profile public figure, I think they do pay more attention and they want to set an example to others because people will be paying attention. They get more attention in the media. So therefore, it seems a bit unfair. I mean, the law should be the same for everyone, but that seems to be the kind of the way it works. So in this case, I think the question will be, well, is Craig Wright a well-known enough figure? I mean, we know him, the people who are watching this know him, but is he really that as well known as a member of parliament? Maybe. I don't know. We're both probably biased on this one. You'd have to ask someone who doesn't know anything about Bitcoin and go, "Who's Craig Wright?" And they'll go, "Who?"
Yeah.
So I think it partly the answer is partly that. I mean, I'm trying not to give a biased answer because I think he did. I think he did commit perjury. Well, I think it's kind of a logical step from the judge saying he's not Satoshi Nakamoto, therefore he lied under oath, which is perjury. It might be a slightly further step to say he submitted forgeries and there was fraud on the court and perverting the course of justice. There's more things you have to consider to get to that point, but the perjury point is clear cut. Whether he should be prosecuted for it, probably it depends on your particular bias or what prejudice you have. You know, in the old-fashioned word of prejudice, you're prejudging because of your experience. The Director of Public Prosecutions at the Crown Prosecution Service may look at this, hopefully will look at this dispassionately and go, well, how bad is it? And should we make an example of him to prevent others from doing this?
Let me ask you this. This is my own question, and it seems to be a popular one on the internet right now. And that is some of the people are saying that Craig told them to sell, and I haven't know if this is true. He said, sell the BTC. I'm going to do a rolling iceberg order and buy BSV or buy BCH back in the day. And then, and then it went down. And then people want to sue Craig for that separately outside this case. And they said they were injured and damaged. Is that a valid claim for someone to say if this is, after this court case?
It's a possible one, I think. These sort of things are much more tricky to get though. Yeah. You're looking at, people mis-selling effectively is what it is. Arguing it, it would be what's the case where you get lots and lots of people together in it?
Class action.
Class action, that's it. It would have to be one of those. You get a class action and all these people say, we were misled into believing that this was going to happen and it didn't, and then we lost lots of money. Those things almost never work, I think.
Yeah, it seems like the lawyers get all the money in those class actions.
Yeah. Yeah.
I've been involved in the few, and I've got 25 cents or I got $2 a few times, and that's about it. So
yeah, I keep hearing radio adverts on thing that's going on in the UK at the moment is did you buy a diesel car in the last 20 years? No, you could be due thousands of pounds because you were missold. Okay, really? Yeah, and the lawyers are going to make the money on that one.
Yeah, they make all the money and the people get a few bucks, if anything. So let me ask you the next one. This guy, this is from CY. Does the Gavin Andreessen signing session stand as is, or was it debunked, or was it taken as fact? And that's probably some of the comments that I made on some videos. So I'd love to hear your perspective.
It was difficult to tell. I don't think the judge can rule either way on that one, and I don't think it really matters. It was discussed. It came up in the Professor Micklejohn's witness testimony and Zemgau's, but it was really a sort of a way of an argument of credibility on whoever's being asked, whether Zemgau's credibility or Micklejohn's credibility, and fundamentally Craig Wright's credibility. Not whether the signing session was in any way proof, because it just wasn't established either way. There's lots of things in that from the court case that are just totally unclear.
Okay, so it sounds like the court wasn't debunked; it just wasn't able to be relied on.
It can't be relied on in either sense. I don't think the judge can decide whether it was proof or whether it was not proof. It's just neither. It's neither here nor there.
Okay, perfect. That's a good explanation. Casper says, why don't they just do a new signing in the court? And I think he's probably referring to getting Craig into court and saying, hey, Craig, can you sign as Satoshi? How come they don't do that or didn't do that?
Well, because all the evidence is in.
It's too late now, right?
it's long gone too late.
Yeah, yeah,
The
it's too late.
the last evidence that was in court um, was actually the email nonsense from between Craig and Ramona and Ontier.
Right. New
So
evidence came in.
that was the last bit of evidence, but that Craig's own lawyers brought that in.
And why don't, maybe a better way to say it is why didn't, it seems like a procedural thing and like direct examination isn't allowed. So like that was I think you said that last time. So like why couldn't Craig's lawyers say, "Hey Craig, go ahead and try to sign a Satoshi"? Like that never even came up. Is that because they don't have direct examination? I mean, why didn't they put him on the stand and make him say, "Do it or not do it"? You know?
Well, it's not something that you need to act out in public. It's just something that you can provide.
Got
So
it.
you can provide a signed statement. So if you have the private key to a particular block, let's say block 9, which is the undisputed Satoshi block, because he sent 10 Bitcoin to Halfini from it. So if you have the private key to the Coinbase address of block 9, and you sign something to the effect of, I am Craig Wright and I own the private key to this block,
That's enough.
signed using the private key to that Coinbase address, then everyone would go, oh, okay, that's pretty good evidence. So because then it's a matter of, well, either you actually are Satoshi and you've had that key all the time, or you've managed to get that somehow. So, okay, if you are Satoshi, then give us a few more, or
Yeah.
maybe sign an email with the PGP key, or we know the email addresses have probably been hacked, so maybe that's not good enough. But there's PGP keys and there's hundreds, how many hundreds or thousands of blocks that Satoshi would have mined over the first couple of years. Just a few samples of those. If you've got the private keys, then at what point do you say stop? We believe you. One
Yeah.
might not be enough, but a few. Okay, okay, we give in. Yeah.
Well, if Dr. Wright watches this video, perhaps he'll take instruction from
He's
you. I really don't
he's
know.
been
So
he's been asked to do that for many years, and he still hasn't.
yeah.
Yeah.
So here's another one. What will happen to you being an expert in patents? So what will happen to the nChain patents if CSW is ruled not to be Satoshi Nakamoto? Do Copa actually have grounds to go after the nChain patents, I guess, in another case?
That's there's a few questions in there. So unpick that a little bit. So what will happen to the nChain patents? Nothing. They're dependent on they're not dependent on what Craig does at all. In fact, now they're dependent on what nChain does. So they just have to keep paying the bills to their patent attorneys. The patents that have already been granted will carry on being granted patents as long as the renewal fees keep getting paid. The applications that are still going through the system, and there are hundreds, there are literally thousands of these going through the system. There are literally hundreds of granted patents. They will carry on going as long as nChain keep paying the patent attorney's bills. Craig really has nothing to do with that. And then the other question is, do Copa actually have any grounds to go after? Well, I wonder, why would Copa want to go after any nChain patents? There are so many. I mean, why would you want to go after? It's difficult for me to count the total number, but I'm estimating somewhere between 500 and 700, something like that, around the world. It will be a very, very expensive job to go after a significant proportion of these. And why would you? Why would you spend money going after patents unless you're being threatened by them? And that's the key, really. If a patent is threatening you, then you start to go after it. And there are a few cases, not many, because he's not being very specific. But Craig Wright has mentioned a few specific patents over the last few years, and kind of threatened a few people occasionally, usually on Twitter, or mentioned it on a Slack group or something. And he's mentioned a patent number, and some of those I've paid attention to and gone, okay, what does that say then? So he's mentioned, this patent covers Lightning, or that patent covers NFTs on Ethereum, or this other patent covers Taproot. And then there's a question of, if someone is feeling threatened by that, they could take a closer look and maybe take action. But it's not really anything to do as a result of nothing of that comes from this trial. It just comes from, if someone is being threatened by a particular infringing a particular patent, they'll start paying attention. They'll look at it more closely and decide whether it's, whether they think it's possibly an infringement, in which case they'll have to start thinking, oh, is it invalid? Then you can start attacking them. But Copa, I don't see them having any reason to start attacking patents in general. Their purpose is to, I should have the core statement. They've got a core statement, which is to keep patents open for open source in cryptocurrencies specifically, something to that effect. And they will, people who have patents like Block or Square or whatever they're called now, Jack Dorsey's outfit, they will put up their patents and say, we will only use these defensively. So if someone attacks us, we will use these patents to attack them. I'm not sure how that works in practice, but the idea is that you don't go attacking people, accusing them of infringing your patents. You only build up a portfolio in defense. So
Nice.
it's a thing. So if then nChain decide to start trying to enforce their patents, then I can see Copa starting to use that defense. They might start pulling out some of their own patents or their members' patents and say, well, hang on, you infringe one of ours.
Mm-hmm.
Or they might say, well, this patent is invalid.
Can
So
you, we got about
really
like 7 or 8 minutes left here. So I want to just, let me,
carry on.
no, it's okay. I want to ask you another patent question here. It's about a guy who claims to have patents.
Oh,
Ready?
yeah.
Have you looked into this? He made a post on
Yeah.
Twitter. It says 74% of our patent sites comes from nChain, a testament to the prolific nature of nChain's IP program. It says that makes me think that BSV may have significantly more value than I realized, since nChain is stating that that BSV users will be licensed through its use. And then here's the thing. So can you speak on this at all, and whether or not it's valid or what it means?
I did look at that, and I thought that's a lot of citations. So is that really correct? I don't know. I couldn't really establish whether that was correct, but it seems that what he's saying is that he's got a patent, and then the later filed applications that mention his patent, a lot of them come from nChain. Is that the orange and the blue? I can't quite see there.
Yeah, the blue is nChain. That's nChain. And then there's some other small ones here that are nChain as well. He's saying that 74% of our patent sites come from nChain.
Yeah. Well, all that means really is that his patent has been cited by
nChain.
lots of nChain patent applications.
Okay, so his patent's been cited by nChain a lot.
I don't think I think it's a bit of a stretch to say that has anything to do with BSV having more value.
Okay,
It's
fair
just
enough.
it's just patent applications citing others.
Let me go back to the other one here. So a couple of the last questions here we had. Let's see. Oh, ask him if a judge in the UK gets appealed against their decision. Does it look bad on their reputation, or is it not a big deal?
I think that's the Bitcoin file format again. So it's not really. It was a fine question, fine legal point that could have gone either way, and it was partly because Craig's attorney didn't really argue the case very well at first instance.
Got it.
Uh, so it's not really down to Mr. Justice Mellor getting it wrong or looking bad. It's just that this is an obscure fine point of law that hasn't been decided before, and it's fairly usual for these things to go up to appeal and get decided differently. So I don't think it would look bad for him at all. It's just
Okay.
something that happens.
And then CY again says, in your legal opinion, is signing enough to say that someone is Satoshi Nakamoto? What would you say it would take to prove someone is Satoshi Nakamoto?
I think we've already done that, haven't we? I mean, I
We
think
did discuss that. We pretty much answered that one already.
yeah,
So
I
we
think
won't go to that one.
one signature would surprise everyone, but they'd start asking, well, where did you get it from? And then more than one signature would start to, that would probably be enough. But
Yeah, those are pretty much all the good questions. There's some funny ones
yeah.
that talk about my hair and other things, but
Yeah.
other than that, okay, we got about 4 minutes left or so. So it sounds like you're confident in the court's ruling. Summarize that as to what it said. That's
Yeah.
okay.
Yeah. I'm not confident in how long it's going to take him to write it. I know he did the only thing I can compare it to is that this time last year, when I met him, he said he was halfway through writing a judgment,
Oh,
and he taking a break at this seminar that I was attending.
someone asked me about your they were wondering about whether or not I think it was when I was in San Francisco, just at a conference here recently. Someone asked me, "Oh, so Mr. Pearce had met the judge at
Yeah.
dinner. Isn't that suspect? They're friends, And I thought, I don't know. Is there something wrong with you going to dinner with the Justice Miller? I mean, that was just a question.
I did no. Well, I knew he was going to be involved in at least one of the cases, and I'd written something about Bitcoin, the database right issue with Bitcoin, which I thought was interesting because I'd not looked at that for about 20 years since I did my MSc. So I got myself up to speed on that, and I discussed that with him because he was the world leading expert in database rights. So that was interesting. But then he said, "Oh, I've been handed these 4 cases," and I thought, "Oh, okay, I better not say anything more because I knew I don't want to start trying to be seen to sway a judge on these cases, which I know are important." So no, we didn't go into any of the details about the actual cases for exactly that reason that you just said. I didn't want to get into it saying anything about what Craig Wright was or what his history was or whether he was credible or anything. No, we just didn't go there
Good.
because it,
Okay.
it wasn't a good
That's
idea.
puts that to bed. So that wasn't what the meeting was about for all the people who think that you
Oh
were
no,
meeting about Craig Wright.
no. It was a seminar on construction of claims in patent cases around Europe,
Got it.
and
Nothing to do with this case.
because
So
he's an IP judge, he was there to present on how you interpret claims in the light of the description for patent infringement.
So, okay, in the last couple minutes here, can you give any words of encouragement to both sides? I mean, people are probably celebrating on one side, and maybe they're upset on the other side. Or what should you what do you have to tell the audience here on both sides of the aisle?
I think it will probably take at least another 6 to 8 weeks, and then we'll have the judgment, and then we can all meet again and decide what it actually says. But until then, it's okay. We know the judge has decided he's not Satoshi, so we go from there. We can all discuss what happens afterwards, but there's nothing really to discuss until the judgment comes.
So sounds like a plan. Then we'll go ahead and do another. Let's do another show then once the judgment comes out, and I would love to have you help kind of break it down what it says.
Okay, well, I might need some time to read it though. It's going to be
Yeah,
long.
I'm sure it'll be long. So we'd love to review it and analyze it and break it apart. I'm sure it'll be really interesting.
Okay.
Yeah, nice. All right. Well, thank you, David. It's super cool. I'm going to be out there in a couple months, and so hopefully I'll get some good vibes there on the other side of the pond, and
Okay.
really
The
Let's stay in touch on Twitter. I love your posts. Oh, how can people find you on Twitter?
Tufty the cat.
Yeah.
I've been Tufty the cat since 2009. I used to just write about IP patents mainly, but yeah, I sort of morphed into this.
And I'll link,
Action.
you and I connect. I'll link your blog inside the description for anyone who wants to read your blog article about what we talked about. So I'll put that in there as well.
Yeah, there's like maybe three or four articles in there that over the last year or so. So the Bitcoin file format, there's one on database rights. I think there's another couple as well on patents in general.
Nice. I'll put those in the description. Contact David Pearce on Twitter, Tufty the Dr. Tufty the cat. Is it Dr. Tufty the cat? Is that it?
I do have a PhD. My cat doesn't.
Okay, you're the doctor. The cat's not. So clarify that.
Well, the cat died 12 years ago, but I just kept his name. But yeah,
I love it. Well, it's super great to have you again, my friend. I really appreciate your perspective, and it sounds like everyone else does as well. So I look forward to doing this again once we get the judgment.
All right, excellent.
Okay, thank you, David. See
Thank you
you
very
at the
much,
top.
Gavin.